Welcome to a live stream. Jelly beans. What's up, Erica? Hi, Marty. What's going on, Northwest? Mantu. I'm sure Eileen's out there somewhere. And last but not least, morning, Mom. How you doing? We're getting spun up for the weekend case review. Got some new stuff to watch today. Going to start things off with Judge Mogen. Move directly into Judge Stevens. We got about 2 hours full of cases. Get yourself ready. Things are getting started real soon. Women Twitter, good to see you. Magic, I'll never say hello to you enough. Hello, Magic Jade. Northwest, Mom, keep these people straight. Erica, good to see you. Happy Saturday, happy Saturday, happy Saturday. Eileen, I was just saying good morning to you. I don't know if you were actually here when I said good morning. Good morning, Eileen. It's always good to see you. Ladies and gentlemen, it's been a long week, but things get started right now.
Oh, I get it now. Okay. Ms. Kuchera, I don't have your attorney. He should be calling in or something. Okay. Don't need to go there. Go here.
Please try again. The number you have entered has not been recognized.
How I am not.
Please try again.
Maybe it's a 612
You
number.
have entered has not been recognized.
I'm gonna try looking him up. That's what I'm gonna try to do. He's disbarred. Oh,
Not yet.
well,
Not in Wisconsin. There's
Okay.
a pending case.
oh, well,
He's only disbarred in
just in
Minnesota.
Minnesota. Just in Minnesota. Alrighty then. Prominent Twin Cities Michael Padden disbarred. Prominent Twin Cities attorney Michael Padden disbarred. Well, his number is not recognized, so
Maybe he thinks he's disbarred in Wisconsin, because I know that Minnesota filed a complaint against him in Wisconsin on
I'm gonna
October
probably
17th.
say you need a new attorney. Probably what I'm gonna say. Probably. Do you pay him? I'd probably get your money back. Probably do that. Or ask for it, but sorry. Yeah, because that's the new news is prominent Twin Cities attorney Michael Padden disbarred, not just suspended, disbarred, cut, throw, gone. Okay, so I'm gonna give you some time to find somebody else. All right,
For what it's worth, he never filed a discovery demand and we haven't provided any.
I don't know how much you've paid him. You don't have to tell me, but I would try and get that back. Just friendly advice. All right, so. Did it take you a lot of time to save what you needed to get to him? Oh, wait, okay, Miss Kuchera, Kuchera, I'm gonna get it, I promise. Miss Kuchera, why don't you come have a seat up here? Because I'm gonna guess you don't want him anymore and he can't even probably practice anymore, so can we just remove him?
Yes.
And then we can just talk?
Yeah.
All right. We will go on the record in the matter 24 CM 213, State of Wisconsin versus Casey Kuchera. The state appears through District Attorney Kevin Schmidt in person. Ms. Kuchera appears in person without counsel Michael Padden. The court attempted to call Michael Padden's number 3 times. All times it came back that this number is no longer, doesn't exist. The court searched for Michael Padden's contact information. When the court did a search for Michael Padden to get additional contact information to call Mr. Padden to notify him of his tardiness for today's hearing. Big headline from January 4th came up saying prominent Twin Cities attorney Michael Padden disbarred. So that just leaves me to believe that perhaps he's not able to represent Ms. Kuchera, and Ms. Kuchera has personally paid for his services. So Ms. Kuchera, you have a few things that you need to take care of. I'm gonna guess that even hearing that news, even if by some chance, some grace of God, he may still have his license here in Wisconsin, hearing that he's disbarred in Minnesota probably gives you a little bit of angst.
And I had just contacted him Monday to remind him that we had court and he never mentioned it.
Oh, well, it's kind of interesting. Did you contact him on the number I just contacted him at?
I can give you the number.
I would love it if you could, because I just called this number and it says it doesn't work. Okay, well, that's not the number that I have. And that's not the number that came up. I don't know. And here's the thing. It's up to you and whatever you want to do. If you want him to continue as your attorney, that's your right. If you don't, that's your right too. Completely, whatever you want to do. I called the case because you have $1,000 posted because you failed to come to court. So there's $1,000 posted. And what I was going to do was going to see if you wanted him to continue. If you didn't, I was going to remove him, and I was going to see if there was an offer, and I was going to see if there was any restitution. But I'm just going to ask if there is any restitution, because I don't have any disposition supplement. No, there's no restitution here. And so I'm not even sure where this case is going. I don't even know what's going to happen. Off the record, your attorney stated that there, and I'm noticing in my electronic file, no demand for discovery has been done yet.
Yeah, and I thought that was kind of odd myself.
Therefore, it's kind of at a still, nothing's happening. So I don't know what you want to do. We can't talk about the case or where it's going or even an offer if you're keeping Mr. Patton as your counsel. He fails to appear. You said you talked to him on Monday, reminded him, you, the client, reminded the attorney, the client, reminded the attorney that there was a hearing. That usually goes the other way around. Like usually the attorney has the job of reminding the client, but good for you for being responsible and reminding your attorney who has failed to appear. All right. And again, it's not the court's job to even contact him to appear. He should be appearing, especially when the court gave him permission to appear by video, and he's not appearing by any means. I have Zoom up and there is no appearance. Okay. So I'm not going to put you on the spot. I'd like to know if there's an offer, but I'm just going to kind of do a quick little turnaround to give you time to think about what you want to do. Maybe talk to attorney or ex-attorney Patton and figure it out. Mr. Schmidt.
Offer would be a ticket for 346,675 sub 1. That's owner's liability for failure to stop after accident, which is according to the bail schedule book, $767.50.
$767.50. And what was the statute?
346.675 sub 1. The owner liability version of it is a ticket, not a crime.
All right. So you can think about it even more. And again, I don't even know what's going through your head right now. Okay. I don't know what's going through your head. You probably have a lot. But
honestly, I'm okay with just going ahead and proceeding without Mr. Patton.
And you want to make the intelligent, knowing, and voluntary choice to remove him as your attorney right now. All right. So therefore, the court will strike him and will withdraw him from the record as your counsel. And so you can understand, and now I'm going to see if you understand the offer that's been presented. All right. You have been charged with the crime, hit and run, as a misdemeanor. This hit and run misdemeanor crime has a maximum possible penalty of up to $1,000 fine and up to 6 months of jail. Okay. Mr. Schmidt has made an offer to you to amend it to a ticket. All right. To a ticket for $767.50 under owner's liability for failure to notify of an accident. Okay. You have $1,000 posted. That would cover a ticket if that's what you wish to do. I can give you time to think about this and have you come back in the next week or so. We can take care of it here today. Whatever you want to do. I don't want to put you on the spot. This is a lot for you to think about.
I'm okay with just taking the ticket and just going ahead and getting this over with.
You want to accept the responsibility, be accountable for your actions, and take a ticket for the fine.
Yes.
All right. Mr. Schmidt, formal motion to amend under the owner's liability for failure to notify of an accident.
So made.
Court will grant that. How do you wish to plead? Either no contest or guilty. Doesn't matter. I'm okay with either. No contest. Court will enter a no contest on your behalf here today. I will assess $767.50. You have $1,000 cash bond posted. That will go towards this ticket. The remaining will be sent to the person, the individual who posted it, to the address that they provided, okay?
Yep.
All right. Do you have any questions? Good luck. I'm sorry. Good luck. All right. Thank you. We are adjourned. We will go on the record in the matters 23 CF 189, 24 CF 163, State of Wisconsin versus Christopher Stewart. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Stewart in person with counsel Nicholas Davis. We're set here today in this matter for two things. One is for a status conference on 24 CF 163, and the other is for a sentencing hearing in 23 CF 189. Mr. Davis, can you please give me a status on the 24 matter before we proceed?
Your Honor, it's not resolved, but may I ask you for a little more patience? I think it has the potential to resolve. I just need another opportunity to speak with District Attorney Schmidt. I'm not asking for that 90-day mumbo jumbo. If I can just have 30 days, Judge, I'd appreciate it.
All right, for that matter, all right. And we are in victims' rights compliance for that matter, yes. Okay. And are we in victims' rights compliance for the 23 case? Yes. Okay. Are we ready to proceed on the 23 matter?
Yes, Your Honor.
Okay. Well, with the 24 matter, Mr. Schmidt, Mr. Davis is asking for additional time to be able to negotiate with you to see if the matter can resolve or if we do need to set the matter for trial. I don't believe that we've had any type of speedy disposition request from either Mr. Stewart or from victims. I do know that victims would like to get the matter resolved as quickly as we can, but not, it hasn't been requested to get it done now, so to speak. So is an additional 30 days objected to?
No, and basically nobody wants to have trials where young children have to testify if they don't have to.
All right, so then that's fine with the 24 matter. So we can go ahead and get that set right now for an additional status and see where we're going to go with that. Mr. Davis, you are coming back on February 10th at 11:30. February 10th at 11:30. We can go ahead and set that at that time.
Yes, Your Honor. Thank you, Your Honor. Your Honor,
What's
and
the date on that?
What?
I missed the date on that.
February 10th at 11:30.
Right.
Your Honor, those other two matters, you allow me to appear by Zoom. May I appear by Zoom for this, please?
You may.
Thank you.
Okay. Now, let's proceed to 23 CF 189 for sentencing. Mr. Schmidt, you may begin.
Sure. This is kind of a hard one to do for sentencing, in part because it's a deferred judgment conviction that got revoked for commission of a new crime. The defendant has not been convicted of the new crime. He's presumed innocent of it. Normally what I would say in these cases is I usually go for a probation first when there's revocation of a DJOC, and that's because most of our revocations for DJOCs are for non-payment of fine or them not doing like the programming required on the DJOC. Mr. Stewart's done the programming on this DJOC, so probation, do anger management, DV, that would make sense because he's already done that. I'm going to be asking for some jail time on this, and the reason why has to do with his history. If you look at CCAP, Mr. Stewart looks like he doesn't have much history. If you look at CCAP, you see a single forfeiture ticket in Grantsburg for DC. You see Minnesota, some weird misdemeanors for traffic violations regarding equipment violations in a 2008 DUI, and that's it. When I look at it in protect, though, I see there've been a lot of charges filed against Mr. Stewart over the year, and I wondered why none of those show up on CCAP. And the reason why is 2019, Mr. Stewart, domestic DC, did a DJOC there, completed it. That's why it's not in CCAP, got dismissed. Did a DPA on another domestic DC in 2017, completed that, got dismissed. Ordinance on a DC in 2014, another ordinance on a DC in 2014, ordinance on a domestic DC 2011, 2005, felony child abuse, DPA completed, dismissed. So there is a trend that goes back 20 years, at least to disorderly behavior, domestic related behavior. That's gone unabated. It also shows that when he's completed numerous DPAs and DGOCs, meaning he's done the conditions without getting in trouble on those. This would be the first one I believe he hasn't. For that reason, I think the court for this, the DGOC wound up being on the misdemeanor battery. I think the court should consider jail time between 3 and 6 months. I think 9 months would be too much because I don't know how much jail he's done in his life. It can't be a lot. I can't imagine he's done more than 10 days jail at a time. So ratcheting up to 9 months wouldn't make sense given his lack of actual criminal history. But I think because I don't see what probation would do in this case, we're supposed to first consider probation. I don't know what need they would actually address because he's fulfilled the programming requirement of the DJOC. I think that we're really about punishment and we're really about like deterring the behavior. I'm hopeful that getting jail for the first time for this sort of conduct ever might deter his behavior better because he's been charged with it and gotten ordinance or DPAs and DJOCs constantly for this sort of behavior. Thank you.
So I guess I missed, how much did you ask for?
I asked for between 3 and 6 months, Joe.
3 to 6 months. All right. Mr. Davis.
Thank you very much, Your Honor. So, Your Honor, while that may be true that he have had deferred cases in the past and successfully completed them, that resulted in no conviction. And so you have to look at the convictions, not stuff that was where he did not get convictions or receive convictions, whether it be an ordinance or deferred. Now, Judge, this is a lot different from those other cases, and I'm going to be quite poignant on this. We were prepared to go to trial on this, and the issue, first of all, I'll say that this is a serious offense. I think it's a lazy argument to say it's a misdemeanor or it's a low-level felony. Let's just get that out of the way. This is a conviction. This does not bode well on his record. My client is employed full-time, and he will not get business if people start doing searches on him and seeing misdemeanor convictions. That doesn't help him. Or if he wants to switch and go to a company or a different company, this obviously isn't going to be a badge of honor. But this specific situation, so he was building a house, and he has his daughter. It's a separated family. They're divorced. So there's the child, the ex, and he, and they have shared placement time. And she comes over, and every time she's at that teenage age where she'd have chores, she wouldn't do them. She wouldn't do her homework. She wouldn't help with the chores. She wanted a new house, and he did everything to build this new house on what I call a creek, not a river, but a beautiful home that he wanted to build for he and his daughter. And they were working. And he kept telling her, will you start helping? Will you start helping clean up the lumber? And he did take a piece of lumber, Your Honor, and he did not intentionally throw it at her, but he threw it in her direction, and the board hit her. And he was frustrated parent. He wasn't trying to hit her or smack her or take a board and hit anybody. He's like, come on, you just help, start working, start helping with the chores, help me around here. Not just don't come over and sit on your phone or your iPad or whatever it is. Now, yes, he could have tried something different, maybe grounded her or time out, but he threw a board, but he did not try to take that board and throw it at her and hit her with it. In any event, he understood that that's not how to handle that situation. He entered into the deferred judgment of conviction, and he did have some requirements to do an anger management assessment and follow through, which he did do, Your Honor. And then I believe he also had another assessment with, I think, parenting and child parenting, and I believe he completed that. What's really tough right now is that he hasn't had much contact with her and hasn't even had so much as seen her in months, didn't see her for the holidays. And now I believe she's moved from Grantsburg School, Your Honor, where she's always gone, and now she's moved to Pine City School. Her grades are abhorrent. Her grades were not doing well in Grantsburg, but I believe they're even worse now. And so I know that children, they like to make decisions. And I know that if you're under 18, you're a minor, you're a child. And it's a lot easier, Judge, I know you've seen this, to be with a parent that gives you the freedom, the video games, that can do whatever you want, and all these things. And yeah, that's nice. And sometimes the parents migrate towards that. And sometimes the parent that has homework time, we sit down for dinner together. You need to help me with some of these projects around the house, and you have chores. Yeah, that's not the fun parent. I know that. I had two parents like that, and there's always a chores, or there's always something. And when I'd see my friends playing or skateboarding or swimming, and I'd have to do these things, yeah, I thought I had the worst parents in the world. But looking back, I didn't. I had parents that cared enough to want to see me have some structure and succeed. What I'm getting at is he's got this criminal conviction for misdemeanor battery, and his daughter was involved in this. And again, he took a piece of lumber and he was upset with her. But I just want you to know, Judge, he did not throw that to hit her with it. He was, get going, get your butt moving here, help me out. So, Your Honor, he does work. He makes all his child support payments. He does whatever he can to support his daughter. Strike that. I don't know if there are, I'm going to strike that, the child support payments. I don't know enough about.
I know that. And I saw him say, no, he doesn't.
Well, and I don't know, I don't do family law anymore, and I'm certainly not representing him in this family law case. And I think there's something going right now currently with that. But so I'm not representing him on that. But I do know that when it comes to any extracurricular, or if there's clothing or whatever it needs, she's not denied any of that. And quite frankly, he's going through, I think, hell right now because he can't talk to her. I don't think the mother's allowing him to speak to her. And quite frankly, I don't think there's any order of this court that denies him that contact. I think if he is to be around her, it's got to be with someone supervised or someone 100% there with eye contact around him. I think that's my understanding with any 18-year-old or younger. But in any event, he's still being denied that access. And so I don't, again, I understand, is this a serious offense? Yes. What is the character of the defendant and his rehabilitative needs? I think his character is strong. I think he did everything he could to follow the deferred. Again, he's got another charge pending, but he does enjoy the presumption of innocence. And that case, again, is not resolved. And I don't want to go any further into that because there's really no reason. It's the presumption of innocence, but it's because of that case is the catalyst, and it did not involve his daughter. It's because of that case we're here for this. And it had not been for that, I know he would have successfully completed this agreement. So what's the need to protect the public? Well, now he's not around his daughter. And it's basically just him and working, but he's not an alcoholic. He's not a drug user. He's a hardworking man, pays his taxes and supports anything he can with regard to his daughter's success. And so, Your Honor, the only thing that I can think of is I know anger management. I understand what it is. I understand what the assessment is, but sometimes I think the domestic violence assessment, which is much different, and usually that entails fall through. It also entails that the therapist needs to see the criminal complaint and as much documents as they can see. And I think sometimes that assessment may be something that may be more forthcoming or can see if there is any issues there because it was his daughter. And they are in a domestic relationships and the definition of it. So I think that assessment, I think it's much more in depth. And I think the anger management assessment, while it's good and it can assist, I think that the domestic violence, I think it not only covers anger management, I think it covers a whole litany of things with regard to being a father and how you act. And yes, if you get frustrated also, I think you get frustrated, you don't throw lumber or although I've had many times growing up where maybe my father wasn't right, but I certainly had things like that happen as well, where he was.
And that wasn't right, Mr. Davis.
Well,
That was abuse.
no, I love my father, and it made me a very successful person. He never hit me, but he would say, "Get going, pick it up." He never hit or hit me with any lumber or anything, but he was very hard on me. And I know my father never abused me, and he's a wonderful, wonderful father. But what I'm getting at is he was hard on me, and I think that created a lot of my success. And so I thank him for that. Now, again, this situation, had it been handled differently, maybe he pulled his daughter aside, but I think where his head's at, I really want the court to know this, his head was not to be mean to her, not to hurt her, but he wants her to be successful and have some structure. And again, I don't know anything about the mom. I don't know, but all I know is I don't think there's the same structure there as it is when it's at dad's house. And so he's the mean parent or the bad parent because of that. In any event, Your Honor, I'm asking the court to consider probation. And this is a heavy duty. My client and I discussed this, but I think it should be probation with an imposed and stayed for the whole time. And he completed domestic violence assessment and he follow through. And that way the ball's in his court. So if anything should happen for the term of probation, then he doesn't, not 3 months, not 4 months, but the whole entire deal. I'd ask the court to consider, because he is full-time employed, that he would be allowed Huber, but I think that's a heavy hit. Put it on him, put the anvil on him, and that's an imposed and stayed for the entire time. Thank you very much.
Thank you. Ms. Bauer, do we have any victim impact statements? I have nothing in the file, so I don't know if anyone's going to make a statement.
No, Your Honor.
I received nothing in terms of that.
Is this the victim in the courtroom?
No, Your Honor.
No, this involves a different matter?
Yeah.
All right, okay. Okay. Mr. Stewart, I am now going to turn this over to you. This is going to be your opportunity for you to provide me with any statement that you wish to provide me with. And let me know anything that you wish to let me know as it relates to this matter and any other matter or any other thing that you want me to know and understand. You don't have to, but it's your only opportunity.
I don't know. I don't know.
You don't have to.
You don't have to, but if you want to tell the judge anything now, this is your right to do that. I don't know what's going on.
All right. Mr. Davis, I fully understand where you're going with, where you were coming from with your argument. And I fully get, and when you were telling your story of how you grew up, Mr. Davis, I get it and I understand. I too had very strict parents. I too had a father that was very strict. I too had a father that was very much like Mr. Stewart, not like your father, Mr. Davis. Not like, if I am going to guess 100%, Mr. Davis, your father did not throw a board at you.
No.
I don't know if your father was angry and your father threw things when he was angry, but it's not okay. It is not okay in any way, shape, or form. No way, shape, or form. That is abuse. Even if you had zero intent to hit your daughter, that is abuse. It is abuse. It causes emotional trauma within your child to see you act like an idiot, like a jerk, like even more words that I cannot even say on the record. You were an awful parent that day. And if I read from the criminal complaint of what happened that day and how it went down, the officer responded to the address and made contact with Ben Stewart in the front seat of a pickup with juvenile 1 sitting on the passenger side of the truck. Ben told me he was taking juvenile 1 to get checked out at Burnett Medical Center. I had juvenile victim 1 get out of the truck and talk to her. Juvenile victim 1 was crying. She told me that her dad, Chris, had told her to use the tape measurer when they were working in the yard. Juvenile victim 1 had gotten dirt in the tape measure, and Chris had told her that if she did that, she would not be going deer hunting. Juvenile victim 1 then was upset and told Chris that she was going deer hunting with her uncle, Ben Stewart, and he would be taking her. Chris then threw a board at her, which hit her in her arm. Juvenile victim 1 showed me her forearm, and I could see a mark on her arm where the board had hit her, and a bruise was starting to form. Okay? And then it goes on and says that he threw the board during the argument, but didn't mean to hit juvenile 1. That's what you told the deputy. He thought she would, quote, get out of the way, quote. You thought she would, quote, get out of the way, quote. When you threw a board at her, you hoped you thought she would get out of the way. When you were mad that she got dirt in a tape measure, and now you said, nope, sorry, I'm taking away your pleasure of going deer hunting, which is great to teach a young lady, by the way. And you said, nope, I'm taking away your fun. You're no longer going deer hunting because you got dirt in my tape measure, because I love my tools, because that's what I do. And so I got mad. No, you're not going deer hunting. And then she said, no, Dad. In parentheses, I may not be going deer hunting with you, Dad. I'm going deer hunting with my uncle. And I'm going to presume uncle's your brother, Ben, because Ben at that time, I'm guessing, was siding with juvenile 1. Because how it laid down here is you thought she would get out of the way. You don't get angry over things like dirt in a tape measure. It's not like she was not picking up the lumber. It's not like she wasn't doing her homework. It's not like she wasn't cleaning up her room. She got dirt in the tape measure. And you got upset when she wasn't listening because you were trying to take something of pleasure away from her. And she said, no, Dad, too bad. So you threw a board at her. And your excuse was, I thought she'd get out of the way. But she didn't. Because you know what? A man throwing a board, a heavy, I'm going to guess 2x4, goes fast. If you've ever taken science class or a calculus class or, anything like that, and you do all of those mathematical formulations, they go pretty fast, okay? It's kind of hard for, I think, a 15-year-old, if I'm recalling correctly, to get out of the way. That's rage. That's not a good parent, Mr. Stewart. That's not a good parent at all. That causes trauma that she will have to live with, and she will have to try and figure out throughout her entire life how to resolve with or without having you in her life. Trying to build boundaries with having you as her father, because she doesn't get to choose. She didn't get to have that choice of, God, let me see, who do I want to have my father? Should I be born to, someone famous or Christopher Stewart? I'll choose Christopher Stewart. She didn't get that choice. And I'm not sure if you even truly comprehend and understand your actions that day. Because I'm going to tell you, that's not the first time that has ever happened. I'm guaranteeing you that. I'm guaranteeing that is not the first time you've reacted that way. I'm guaranteeing you that. You know that. I'm sure Mr. Davis knows that. You're acting like you're confused, like that was the first time you've ever acted that way.
First time I guess I've thrown anything.
I don't believe that. I highly don't believe that. I don't. If your anger and your boiling of emotion and frustration got to that level where as Mr. Davis said, your head wasn't right that day, but your head was so explosive that day over dirt in a tape measure. And your daughter saying, no, Dad, Ben's going to take me hunting.
I've always taken her hunting too, but
Correct, but that's not the issue. The issue is not who's taking your daughter hunting that day. The issue is you exploded because she got dirt in your tool. You didn't like that. You tried to take something away from her and she stood up to you. She took control. You did not like that. You reacted, you took what you had, the board in your hand, you took that, you used that as a weapon, you gained control by taking that board and throwing it at your daughter, I guess thinking, I thought she'd get out of the way.
I've threatened to take the cell phone away, but that doesn't work either, so.
Oh, so what, did you try to throw a chair at her that time? Okay,
No, she
so
just, I take it away and say you're gonna do dishes. That was another time. She just goes next door to her aunt's house, calls her mom. Then I'm an asshole for taking the phone away. Sorry about my language, but then so I can't win at any of this. I've tried. I don't know how to shut the phone off. I pay for it, but I don't know anything about them.
but that's not the issue. And here's the thing, what you're trying to do. You're trying to control this situation right now. You're trying to divert this situation of what happened this day, your conduct, your behavior, to throw it back to the other times you weren't able to parent. I don't know. And that doesn't matter here nor there. Here nor there. Today is why you threw a board at your daughter. Why you let your emotions and your anger explode to throw a physical object, a weapon at your daughter that day. Now, do I believe that this does deserve a punishment? Yes, I do. But I do believe that there are other matters in the 24CF case that we need to figure out first, because those are very serious as well. Right now, you're not having contact with your daughter, which is probably a good thing. I can't help her, and I can't order that she get trauma-informed therapy, which she needs. She needs. But what I can order here, I can't do it if I put you in jail right now and I do a straight jail sentence. But what I can do, at least in the meantime of while they're figuring out this 24 case, I can order a whole lot of other things that you do right now. And I can make sure that they're done while we're figuring out what's happening in the 24 case. Because there's a whole lot of things other than anger management and parenting classes and stuff. Those are great. Those are grand. Those are wonderful. Those are not enough. Those are not enough for me to determine whether or not you go and have a full psychological evaluation, that you get evaluated for an in-depth evaluation for narcissism, whether you're a narcissist, whether or not you have a full evaluation of your total mental health, of getting down to all of the nitty gritty of Mr. Stewart and doing all kinds of other things. Because that's what my focus is on right now. I could punish you here today and I could send you to jail for 9 months here today. That's not going to accomplish anything but punishment. And that's not going to do anything in the meantime right now while I'm giving Mr. Schmidt and Mr. Davis time to figure out what's happening in the 24 case. Because I don't know what's going on there. I don't know the facts there. I don't know any of the in-depth there. I don't know what's going on, but I know what's going on here. And I can see here that there's a lot of work that Mr. Stewart needs to do. A full lot of work that you need to do. And I want it done, and I want it done now. So, Mr. Davis, you win. I agree with your argument. Well, not your argument necessarily, but your recommendation. So, at least at this juncture, and at least at this point with this case, I will place you on probation for 1 year. Imposed and stayed jail, 9 months, consecutive to any other sentence.
What that means.
Any other sentence that you may now have or may have in the future.
Your Honor, can you explain to my client what that imposed and stayed means? I don't think
Yes.
he fully got it when I explained it to him.
All right. So an imposed and stayed jail sentence means I will place you on probation. That means you will be on probation for a period of 1 year with certain conditions that I will lay out for you bit by bit, word for word, so you can understand them. If you fail to accomplish my conditions, you violate probation, you will be revoked. If you are revoked, you don't come back in front of me for sentencing. You will immediately go to jail and sit 9 months of jail, okay? So it means you must follow what I'm telling you to the letter, to the T. Do everything that I'm telling you you must do. All right? Okay. Is that a yes? You understand?
Yeah, yes.
Okay. Now, Ms. Bauer, I don't see any restitution. Is victim going through any type of counseling?
That's my knowledge.
I am going to hold open restitution, a hearing for restitution for 45 days so that you can follow up to see if she is doing any counseling or any trauma-informed counseling, because I would like to know that, and I'm sure Mr. Davis would like, or Mr. Davis and Mr. Stewart would like to know that. And if she is, and if that's a possibility, please let the court know and we will schedule a hearing, okay?
Yeah.
All right. So probation, 1 year, 9 months imposed and stayed, again, consecutive to any and all sentences. The court is going to order $1,000 fines, fees, DNA surcharges, all wrapped up in one little bow. Conditions of, you have $250 posted. That means you still have $750 left to pay. That will be paid, that will be due within 30 days to the court here, not to probation. Conditions of probation. 1 is to have a full spectrum, complete mental health, psych evaluation. Absolute sobriety. A full psychological evaluation, which would include a determinate determination of whether or not there's narcissistic personality disorder, any anger disorders, any personality disorders. Again, the absolute sobriety, that means no alcohol, no illegal drugs, no bars, taverns, liquor stores, or establishments that have the primary purpose for the sale or the service of alcohol. No casinos.
I don't go there.
I'm ordering an abuser intervention program treatment. That is a program that's designated to rehabilitate those who repeatedly use violence towards intimate partners or family. Because as it was stated, and yes, I understand, Mr. Davis, your argument that it may not be used for conviction purposes, and the court should not use that in punishment purposes, which I didn't. I didn't send him to jail. However, there is a history here of at least charges as it relates to domestic abuse or domestic abuse enhancers, and they've been reduced to either ordinances and or deferred prosecution agreements or deferred judgment of conviction. Therefore, you must do an abuser intervention program that is designed to rehabilitate or focus on individuals that repeatedly use violence and other actions towards intimate partners and or family members. Gainful employment, we don't have to worry about that, but it is one. No abusive contact with your daughter, but no physical contact unless approved by agent or court. And I don't know what's going on with your child support, but make your child support payments.
Oh.
I don't follow up. I don't keep to follow up, but you're not going to tell me what's going on now. I'm just going to say that's a condition. Pay your child support. Keep it up to date. That means you must go and talk to child support and figure that out. If you fail to pay your fines and fees within 30 days, not only will the court enter a civil judgment against you, I will issue a warrant. You will sit 6 months in jail separately from this 9 months that's been imposed and stayed as for contempt for failing to pay. Very important you pay, okay? All right. What am I missing, Mr. Schmidt?
Nothing from me.
Mr. Davis.
Your Honor, I think he may have one. I know he has 1, maybe 2 days of credit. I'm just not certain.
I'll just put 2 days. I'll give him the benefit of the doubt. 2 days jail credit.
He said he sat overnight, but I don't know if he got in before the midnight hour. I just don't know. So I just want to make sure that I'm not saying I just don't know for sure.
I'm good with 2 days. 2 days is good. So what I'm expecting then on the other cases, we'll have a status in February. I'm not expecting, and I'm not saying that it must be resolved by that February date. This is a very serious case, but I want the victims be able to be assured that it is working towards either a resolution or that we're going to be able to set the matter for trial so that we know where this is going. If we need another status, Mr. Davis, after that February date, I'm fine with that as long as the victims are aware of what is going on.
Your Honor, may I ask a question, please?
Yes.
So I understand what your order is with regard to the bond conditions, but he'll have to wait till he meets with the agent with regard to how that, or if there's any contact with his daughter, correct?
He can, I'm fine if he has telephone contact.
I'll talk to him. I just want to be very careful. She may not want to talk to him too. So but again, I just want to make sure that he follows the rules. And then the other thing, Your Honor, with the abuser intervention, is there a specific place that the court uses here in Burnett County, or can we use any different county for that?
No, I'm not, there is not one in Burnett County. I am not quite sure of if there is exactly one that is used by DOC or not.
So they'll probably, I do know that the psych evaluation, I know there's people that do
I was
that.
looking at Wisconsin DOC when I was looking at that, the primary treatment programs that they have. I was looking at their website when I was saying it.
So we should let the agent set that up then.
Yes.
Okay, all right. All right, understood. But so nothing, I'll go through the post-conviction, nothing further, Your Honor.
All right, so 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must provide your DNA. Failing to provide
to the
that,
agent.
well, you're going to, because you must go report to the jail right now, provide your DNA. Once you're done providing your DNA, you must go report to probation, get all of that set up immediately. This may be something, but I don't know if it is, but it may be a crime that you would be able to have your DNA expunged, but it would need to be a written letter to the Department of Justice, but you would need to do it to the Department of Justice, not to Burnett County. It's easy to do. You can Google it or ask Mr. Davis. Now, I believe that does cover everything, Mr. Schmidt.
The court said a few things about contact with his daughter.
No abusive contact. He can
Yes.
have telephone contact, no physical contact without agent approval.
Well, I'm just wondering because of the bond in the other case.
That just says no victim. That applies to the victim of that matter.
Well, it also says no contact with minors under the age of 18 without full eye supervision. I don't know what full eye supervision means.
It means you have to be in the same room and look at them at all times.
Because the other component of that is, of course, his daughter is a witness against him in that case. She is juvenile witness 1.
Well, it doesn't say, that bond does not say no contact with witnesses. And the
Okay.
state did not ask to have no contact with witnesses. So if you're going to be asking to modify that bond to have no contact with daughter, that would be for the state to motion the court to modify that bond.
To be blunt, I thought the no contact with minors under 18 already covered it.
Does
So-
not.
Okay. We'll file something in that case then.
Well, we're here today, so
That's true. I would ask no contact with his daughter in 24 CF 163 as a condition of bond.
until it's resolved,
Yes.
Mr. Davis.
Well, Your Honor, I would ask for time to prepare for this motion.
Well, what I'm gonna say is there could be no contact with his daughter about the matter specifically relating to 24 CF 163. Ms. Bauer,
The last time I spoke with the victim, she did not want to have contact.
daughter? Well, and she can
She's-
refuse contact all she wants, but I will modify bond that says no. In 24 CF 163, no contact with daughter, or no communication with daughter concerning the facts of this case.
And I will tell him that he'd be insane to do that because he could wind up with more felony charges by doing that.
Can I send a birthday card, Christmas card? I mean, I have it all at home. Just
Yes.
can I do it or not?
I'm not saying no contact. She can refuse it.
You saw the bond, that's so.
I'm just trying to make sure it's clear because I've been waiting for these answers for a long time.
And if she further wants no contact, Ms. Bauer, that would need to be a specific motion because I've never heard that prior to just now.
Anyways, yes, and Your Honor, so he will not mention anything about
case, and she, like you said, she may not want to have contact, and he understands that if he does have contact with her, there's got to be 24/7 eyeballs there of an adult seeing that contact.
Correct.
So yes, he understands that.
All right, anything, but you do understand that she can refuse any contact. Like if she doesn't want that birthday card, she can say refuse, return to sender. Or she can go click, send a voicemail, or she can block, or whatever she wants to do. That's her choice. There is no court order, at least that I'm aware of right now in the family matter, that says that she must have contact with you.
Thank you, Your Honor. Nothing further from the defense.
All right, then we are adjourned. Thank you.
Judge Mogen, ladies and gentlemen. He's a firecracker. I really like that judge a lot. I don't get to cover Burnett as much as I like to, but that's definitely somebody we're going to be watching more of in the coming weeks. Keep an eye out. Those will be videos coming up. Judge Stevens is coming up next, right now. Gallery Court Review.
Twenty-four CR 696 is called the State of Texas versus Travante Conrad. That's you, sir?
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 5th, 2024, in Jefferson County, Texas, you committed the third-degree felony of terroristic threat to a public servant. Do you understand what you were charged with?
Yes, sir.
There was a reason for this disturbing behavior. You face a term of not more than 10 years or less than 2 years in prison. In addition, fine may be assessed not to exceed $10,000. Do you understand?
Sir.
You have to speak out.
Yes, sir.
Okay. An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length. There's no fine or
No, Your
restitution. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Yes.
sir. Yes, sir.
I'll show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily?
Yes, sir.
Understand it. Discuss it with your attorney or the contents true and correct.
Yes, sir.
State's Exhibit 1 tendered and taken.
No objection.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in anti-lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation by your attorney in this case. All true, so help you God. State's Exhibit 1 made part of the record for all purposes.
And Your Honor, the state would also request just part of the condition of probation that it be ordered not to go on the campus there of Lamar University in Beaumont.
No objection. No objection, Your Honor.
Were you a student there?
No, sir. No, sir.
What were you doing over there?
A YouTube video.
A YouTube video on what?
Like just
Education?
talking to girls.
Talking to girls. You know, that's a learning center. It's for education, not for. And you weren't even a student there?
I knew somebody.
So you go there and let's see. Responded to a report of a terroristic threat in the communications building. I'm going to shoot your ass. You're threatening to kill somebody at Lamar University on that campus?
I wouldn't.
And you weren't even a student there? The suspect caused a disruption in the classroom in which Thomas was attending class in. You went in the classroom?
And Your Honor, how it, if I may, how it went down, defendant went into the classroom in a speech class while they were giving speeches. He,
In the
one of the
middle of class?
individuals, yes, sir, in the middle of class, he tells one of them to shut the F up. A much larger football player than him stands up, starts to walk towards him as he's videoing himself and backing out the door. And when he gets him almost completely outside, he says, basically, if you keep coming at me, I'm going to shoot you. Talking to the football player that was essentially walking him out.
So it wasn't threatening a public servant.
No, sir. It's placing the public in a fear, substantial number of individuals in fear of serious bodily injury by him saying he's shooting. Other people did hear that in the class and were fearful of that. So even though he did direct it to the towards the individual, the football player that was walking out.
This caused the class to abruptly cease activities, then the person who was being spoken to asked who the suspect was. So you were live streaming the encounter on an online. Back down to the classroom and stated, "I'm going to shoot your bitch ass," repeatedly, and placed the person, the victim, and other individuals in fear of their lives. Then what were you doing? I still don't understand. Why were you there when you didn't have any business being there and interrupted a class at school? Now I'm talking to you.
I don't think you understand.
Yeah, I only have 3 degrees. I can figure it out. You tell me something, how you were there that makes intelligence.
It's a new thing that goes like live streaming is popular. So I was just, trying to ride the wave. It wasn't my intention to go there and do that.
What was your intention? You disrupted the class.
I had read somebody comment in the chat, told me to tell the teacher to shut up and you were go viral. I just did it. It wasn't my intention though.
You had no business being in that class. These other people pay money to go to school to get education. So you're an outsider. You venture onto the school, disrupt the education program just for fun? Is that it? That's craziness. I don't care what the new fad is. That doesn't have anything to do with right. It's all wrong. Well, you don't put people in fear of their lives, threatening at a school, an education facility. I'm funny about that. Anything else, Dan? Anybody? I'm going to find you have pleaded, you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is made a part of the record for all purposes.
No objection.
Pre-sentence report waived?
Yes, Your Honor.
Anything else to add?
Nothing to stay.
If not, I'm going to find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty and beyond a reasonable doubt. But I'm going to defer a finding of guilt, place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of bizarre conduct. You will, among other things, remain off the premises of Lamar University property unless you somehow begin to act wiser to get an education, which they can help you with because they're a learning institution. You will complete anger management. There will be other terms and conditions of probation, and you will serve 30 days in the county jail. You disrupted people, adults who were trying to get an education. And it was for no other purposes but to disrupt. It had nothing to do with education. You weren't invited there. You brazenly got on those property, in that property, interrupted a class, threatened people with their lives. And you will do 30 days in the county jail, and that begins immediately. That people like you who think others who are trying to get an education are that's not important. Unfortunately, you need to gain wisdom to learn that that's the key to almost every success in life, not the stunts you pull. All that did was harm people, disrupt their lives, and at an educational facility. On my watch, people getting an education are going to be protected from bizarre behavior like you.
I'm not a bad person.
You are what you act. You acted badly, sir. You are how you act. If you're not, you better start acting better than you acted here. That was completely irresponsible behavior. You put people in fear of their lives.
Thank you, Mark.
That is all. Okay. We have three cases. The state of Texas versus Jonathan Brazino, 2199-2200 and 1299. It looks like 2199, there will be a plea entered and the other two cases will be dismissed.
That's correct, Your Honor.
You are Jonathan Brazino, sir?
Yes, sir.
You were here with your attorney, Mr. Burbank, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here in 2199? Can we proceed in summary?
It does, and you may, Your Honor.
In summary, this indictment alleges that on or about September 20th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault, family violence of someone you were having a dating relationship with. This is a third-degree felony. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case, you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length, fined $750. 1299 and cause number 2200 will be dismissed as part of the agreement. Is that your understanding of the agreements?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead to this, sir, in 2199, this third-degree felony, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily, understand it, discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. Among other things, the states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Is a pre-sentence report waived in this case?
We do, Your Honor. We have a question.
If nothing further to add by the parties, I'm going to find, sir, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. But you're getting a second chance.
Yes,
Make
sir.
the most of it.
Yes, sir.
I'm going to place you on deferred or unadjudicated probation for 10 years. You will be fined $750. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be completing the batterer's intervention program or anger management program as deemed appropriate by the probation office and other terms and conditions of probation. Make sure you follow these. If you fail, your probation could be revoked.
Yes, sir.
You could be then found guilty and sentenced up to 10 years in this case, and then those other cases could be resurrected. What am I doing this thing?
I'll have to fill that out too.
Okay.
It has.
You work as fast as you can. And
Thanks, Joe.
please see the probation officer. And the other two cases, 219-1299
We'll be submitting dismissals in those here in just a second, Judge.
and 2200 will be dismissed. You are dismissed. Oh, Tom, I do need to talk to you about something. Two cases are called 24 CR 1520 and 1521, the state of Texas versus Joseph Michael Mortier. Please see the coordinator.
Think up the right thumbprint. Once it flat right there on the box. Pick it up one more time. Okay, that's the bar right there. Okay, and that's me how it goes.
You are Joseph Michael Mortier, present with David Grove, your attorney, and the state's attorney. Does the defendant waive formal readings of these two indictments here? Can we proceed in summary?
Yes, Your Honor.
And we're going to take these up since they're charging the same type of offense on different dates. In 24 CR 1520, this alleges that on or about March 3rd, 2024, and in 24 CR 1521, alleging on or about March 19th, 2024, both indictments stating occurring in Jefferson County, Texas. In each case, you are accused of assault of a pregnant person, third-degree felonies by intentionally, knowingly, and recklessly causing bodily injury to the complainant who you knew was pregnant at the time of the offense. You committed the offense of pushing against the head of the complainant and bending her neck in one case and shoving the complainant, causing her neck to bend, thus causing intentionally, knowingly, and recklessly bodily injury to the victims in each case. You understand what you're charged with here?
Yes, sir.
These are third-degree felonies, which means in each case you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached. You would be, in each case, pleading guilty, placed on deferred or unadjudicated probation up to 10 years. Fined $500 in each case. Any restitution?
No restitution, Your Honor.
There will be no contact between, among other terms and conditions of probation, which I'm going to follow this. No contact between you and the victim. You have children in common with the victim.
Yes, sir.
You will be allowed to have contact with the children with supervision. And that's all going to have to get worked out in detail, because if you don't do that in detail, the plan always comes apart because people read into things when that wasn't the intent. So it needs to be specified.
Yes, sir.
But that's the general agreement. Correct. If I follow these agreements, in each case, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in each of these cases? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 in each case, David. Thank you. Did you sign those documents voluntarily?
Yes, sir.
Did you understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence in each case.
No objection.
Without objection admitted. These state that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictments been wrote to you. You read them. You were guilty of the crime charged and any lesser included offenses in each case. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true in each case. It states, so help you God.
Yes, sir.
In each case, State's Exhibit 1 is made a part of the record for all purposes. Will please send us reports, Wayne?
Yes, Your Honor.
With nothing further to add, I'm going to find, sir, in each of these cases, you were pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. From State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation, so long as you follow terms and conditions of probation, which are normal for this type of offense. You will be required to complete the batterer's intervention program and complete a moral reclamation therapy, MRT, as directed by the probation office. All of those are to help you be a better person and understand and appreciate the ramifications of these serious accusations and get you on toward following all the rules properly when they involve this type of behavior, children and mother of children. Do you understand what has happened today, sir?
Yes, sir.
The only other thing is in the agreement here, it states that do you have a common child or children? One child. All right. Well, you will be allowed as a condition of probation. You are going to be restricted in your visitation. You certainly aren't allowed to see the complainant or contact the complainant. But I guess there's some kind of allowance we have to make when there's a common child and they're making arrangements to see the child. He's going to have that right. He'll be allowed to see the child under a court supervision method under the order. And it says when court deems it appropriate. And I'm really at a loss. I don't know much of what that was meant to be. Ms. Staub, can you explain that?
We meant it to be when he's successfully finished all of his classes and he's gotten his treatment. We don't want him to immediately start seeing the child, as we don't know how he's going to be at this point. It was the child that she was pregnant with when she was assaulted. So we just want to make sure that we're watching him and that he's done all of his classes and he's not on drugs when he sees the child.
Was it a drug issue? All right, we've got to deal with that. That's going to have to be dealt with. He's going to have to be tested so that we know that he's doesn't have a drug problem now. But if he does, if the probation office deems there is a drug issue, we need to get some assistance, because assaulting a child in the womb is a mother who's got a child in the womb is pathetic conduct. It's irresponsible. It is not allowed, it's disallowed, and it has ramifications. You don't want to hurt anybody, much less a child.
Judge, since he is going to be supervised by the Jefferson County Probation Department, I think we had assumed, although the court can do whatever you want to, I understand that, that you could not have the mother supervising it because that's where you run into the victim contact.
So what do we do?
So I would say the only other reasonable thing I could say is possibly through the probation department, or there is also a local group that supervised is not in criminal cases as much, but in family law cases.
Who are you talking about?
Well, basically,
No, what group?
they're out of Nederland. I just cannot remember the name.
We have family services here in Beaumont, and they
Yes, sir.
come on the board
And that-
there, and
that could-
they do a
that
good
could-
job.
It's also the type thing where CPS does some of these supervisions. So there are other things that are
I'm
available.
going to ask the probation office to kind of do some legwork on this one so that because he's going to be released here shortly, and there needs to be certainty in
Judge,
how often this is going to happen and under what conditions. Yeah.
complaining witness no longer lives in this county, so we'll have to deal with that later when we get to the classes and everything. I think we'll work it out. Huh? You have it. You want me to say something? Well, sure.
Here, but the other thing is, hold on. Is a condition of probation that he not leave Jefferson County?
Yes, but
Is that what y'all are asking
right
for?
now, yes, sir.
Yes, sir.
That's fine, Judge, except that the child is in Harris County. It's going to make it a lot more difficult to have any type of.
Well, the agreement is that he has.
That's fine,
he's
Judge.
entitled to that visitation under chaperone.
Yes, sir.
But we're gonna have to iron that out a little bit, sir.
Yes, sir. The programs.
Yes.
Yeah, we gotta go to programs first and then go to that. Okay,
Yeah,
and if there's an,
back on
and
this.
if that's either party, if that's a problem, when we start addressing this, let the court know so we can get that dealt with as soon as possible.
Yes, sir.
But you don't wanna, these are third-degree felonies, right?
Okay.
I mean, you got, you're looking at up to 10 years in prison.
You can call.
And, you know, that's pretty serious. You don't want that to happen. Okay. What's next?
We have a victim impact statement, Your Honor. Allocution.
No, I'm good stuff.
I believe I've signed both these. Okay. Go ahead. On that, how do y'all want to do that?
So you stand right here, look.
She may.
Oh, never mind. I guess we'll stand over there.
Where do you want us to sign or to stand, Judge?
Okay. You stand just next to David, right there. Thank you, sir. And your name, ma'am?
Mortier.
Okay, go ahead.
I started sitting out in the truck writing this, I didn't finish writing it. So I wrote it to me and I'm just gonna go through my head, but I said, I don't even know where to begin or what to say. I'm standing here holding my son, who I was pregnant with when you did all the stuff that got us where we are today. I didn't ask to get a victim impact statement for you. I know you know how I feel. I asked to be able to get one for me, to get a sense of closure on this chapter of my life. 10 years is a long time, a really long time, and I don't want to go all those years with things left unsaid. I know most people think I'm crazy, for not running as fast and as far away from you as I possibly can. Half the time, I think I'm crazy for it too. Maybe I'm foolish or naive or too caring and unforgiving. There's cases all over the world similar to this one. There's women in graveyards all over this country who have protective order in place, but the other they walk right through. Am I scared? Yes, more than I let on. I know deep down that drugs cause your behavior. I know this isn't who you are before. That knowledge doesn't lessen the pain or trauma. It doesn't ease the fear. It doesn't help anything, actually. It makes it all so much harder. If I really believed you were a bad person, it would be so easy to walk away and forget all of this. I don't think that you're a bad person. I think that you made really bad decisions under the influence of some really good stuff. And I don't want to keep your son from you. I want you to be an active part of his life as much as you want to be. But I have to protect him. I have to know that he's safe before I let you interact with him. I need you, please do the work in the classes. Don't do the TDC classes. Don't just give cop-out answers. Cop-out answers is what got us where we are right now. And I never wanted it to be this way. It wasn't ever supposed to be this way. You were supposed to hold him first. You were supposed to hold him first. I've loved you as long as I can remember. And this is one of the worst things I've ever had to go through. Not just what happened, but all of the stuff that unfolded after it. I don't want him to grow up not knowing you. I really don't. But I need you to be a good person, and I need you to be a good dad. He needs you to be a good dad. I don't want you to hold a grudge about this. I don't want you to be mad at me because of all the classes and stuff. I have advocated for you more than I probably should have to try and help get to this point where we are right now. And Sarah can vouch. I've gone back and forth with, do I want him in jail so I know that me and the baby are safe, or do I not? And ultimately, I want you to get better because I know that what happened isn't who you really are. My heart hurts for me, for him, for you. He needs both of us. He's got so many medical issues. He's got laryngeal malacia. He's got reflux up to his thoracic inlet. He's got gastroparesis, heterogeneity of his liver, dilated bile ducts. The list goes on and on and on. He's been hospitalized 4 times for failure to thrive. He's been on the failure to thrive side of the growth curve forever. He's finally getting out of that. And it's hard. It's hard being a single mom, dealing with all of that and not having you there when you want to be, but me being terrified. I need you. He needs you, but we need you healthy and we need you in a good frame of mind. And I'm sorry to use it too hard. I really am. If you don't do it for anybody else, please do it for your son. Do it for me. Please.
Anything else? That is all.
No, Your Honor, nothing.
Thank you. We now call cause number 24. CR 1400, the state of Texas versus Charles W. Kerr. That's you,
Yes, sir.
Mr. Kerr? Present with John West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, sir, this indictment alleges that on or about May 24th, 2024 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you're charged with?
Sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. So no less than 2, no more than 20 years confinement is what you're looking at as the range of punishment. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, sentenced to 2 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1 there. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true. So help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. God bless you. Do you understand
Yes, sir.
the situation here? And is there anything else this defense or the state wishes to add?
No, Your Honor. No.
Okay.
Yeah.
I'm going to follow this agreement and find, sir, you were pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. Do you understand what has happened today, sir?
Yes, sir.
I'm looking at this probable cause affidavit and looks like this was precipitated by synthetic marijuana.
Sir.
You don't even know what's in there. And nobody does. I mean, it's made on these clandestine labs and what goes in it is hallucinating. You don't know. But you understand when you willingly use it, you take the responsibilities of ramifications that can happen, such as acting bizarre during an arrest situation like this.
Sir, I'm sorry.
But everybody knows that you don't know what's in there unless you make it yourself. But then what a foolish thing to do. That's a crime. Yeah, it's not a defense.
I promise.
Sir?
I said, I'm definitely learning my lesson. I promise.
Have you? Well, you gotta carry it out in actions.
Yes, sir.
All right. Have you ever been convicted before?
Just of a state jail felony.
Well, just of a state jail. That's a felony.
And I was really innocent of that felony. I just had 5 statements saying I wasn't. I'm serious.
Look, you just wasted your breath on that because the fact of the matter is you were found guilty.
I know.
If you were not guilty, that should have been dealt with at the right time, not later on. It's history. It can't be resurrected. And that's why we go through all this dog and pony routine to make sure that everybody that decides they're going to plead guilty. Did you plead guilty in the case?
Yes, sir.
Okay.
Well,
you took an oath.
I didn't want to fight it in 6
I don't
months
care.
at a time.
I don't care. But here it is. It says just like this. I swear all of this is true and I am guilty of the offense and all lesser included offenses. I swear all the foregoing is true. So help me God. You would have signed something just like that.
Mm-hmm.
Well, so you committed perjury too at the end of this by swearing something was true when it wasn't?
I just listened to what my lawyer told me to do.
Well, one of my lawyers here?
No, this was in Orange.
Well,
different county.
Well, but generally speaking, the lawyers do their jobs, but you know better than to lie under oath. But when you do that, if you did that, you signed a document, it's hard.
They told
You
me I
can't
was
really
just as guilty
talk about
I
it.
accepted money from the dude. And
Sir, if
that's
you
why I
pleaded guilty under oath, if you're now saying I'm not guilty, then you're
No, I
telling
didn't
me
think
I
go-
committed
No, what I'm
perjury.
trying to tell you is I didn't go steal nothing. This dude did. I was
Yeah.
guilty because I accepted money from him.
Well, I don't know how they do it in Orange, but
That's what they told me I was guilty for on camera was accepting money for him.
Yeah, we tried 600 jury trials in this room. I tried. And that means people who have issues get a chance to be heard and have a trial. And they should be doing that over there in Ames County too, you know. If you wanted a trial, that's what you fight for, you know. But the point is that's done, unless you want to say, yeah, I'm looking at perjury now, undo that case. But you can't look backwards, you got to look forward. So from here on, how are you going to conduct yourself? Under the, you're stuck with these now, you got 2 convictions. What are you going to do about it? Better? Make better choices? Okay, all right. All right. You have a family or something that you take care of?
I have a little boy that my mom has right now. I got 2 little girls.
It was just Christmas. What's the greatest gift you could have given the child?
My freedom.
No. The greatest gift you can give a child is a good example.
Well,
as
yes,
a
sir.
father.
I thought you was talking about at Christmas while I was incarcerated.
And I hear people say, well, I'll give them a toy gun or something. I said, you're missing the point. The best gift you give a child is a good example, because they're going to naturally emulate you, because it's natural for them to want to do what their father does or their mother does. So
Yes, sir.
you got to live a good example, especially it's just not your life now. You've got a child.
Yes, sir.
It's going to be influenced by your actions. So you want to live a good life.
Yes, sir.
So he's proud of you and emulate you, right?
Yes, sir.
Do it.
Yes, sir.
Go, okay. Fix this, and move on, do better.
Yes, sir.
That is all.
Thank you.
Okay, who do we have now?
Mr. Senegal.
Mr. Senegal, that's you? Okay. Here is this. Where's Mr. Senegal's file?
Handed it back to you, Judge. That motion. He withdraws.
Hey, let me look at least 2 places.
He's in trial on with, Mr. Burbank.
Just put
Yeah.
them aside because I keep mixing them up.
Oh, yeah.
All right, we now call Xavier Senegal. That's you, Mr.
Yes, sir.
Senegal?
Yes, sir.
And you were here with your attorney, Mr. Vasquez. There was today, it looks like something was filed, a motion to withdraw. Is this filed by you, Mr. Vasquez?
Yes, sure.
Let me get a quick one. I remember this.
Oh, Judge, here, it's on the column.
It's
Okay. This is very frustrating to the court, of course, because everybody needs to have a case move forward quickly, and this one's almost 900 days old. And we are getting toward, at the time of trial, what would otherwise be called a stalling tactic of asking for a new lawyer. And I see this 3-page letter that you have handwritten letter that you sent in October 28th, essentially stating you don't think Mr. Vasquez is representing you worth a darn.
yes, sir.
And can you articulate in summary what he has failed to do that you feel like
Well,
he should have done?
first of all, I mean, I had this man in 2013 and I fired him daily on the case. And not just that, I mean, due to his ineffective assistance, then,
Let me ask, did you hire him back?
no, sir.
Okay, you were appointed. So
Yes,
the
sir.
taxpayers have been paying your way in all of this, right? Well, that's appointed. He doesn't get paid by you. He's getting paid by me and other taxpayers. But the point is the law says you don't get to hire and fire anybody that, as long as they're competent. You may not like the way they do things and disagree, but that's tough. Go hire your own lawyer. If you can't hire your own lawyer, then you get people who the judges have deemed competent to represent the cases, and he's one of those. And here's the deal is you don't people get frustrated because for whatever it is, sometimes they don't get along. They don't see eye to eye with their attorney. But the answer to that is go hire another one. But you say, well, I'm unable to hire one. Then the rules are different. You're not entitled to somebody you like or you want. You're entitled to a competent lawyer, and you interrupt me just then. Let me finish. She can't take both people speaking at one time, and she's got to take everything. You want me to put you in timeout? You're going to interrupt me a second time in 10 seconds? I don't. You find this funny? It's your life. No, it's not. But you laugh and you interrupt. You interrupt. You just laughed. And don't say you didn't laugh. I've lived long. I know what a laugh is. You think this is not serious? Of course it is. It's the Constitution. And that's the Constitution.
Sir, it is.
Well, don't laugh about it. And let's get to the point. What is it you don't like about him that you feel like another of the taxpayers' money should be spent on?
Not one time has Mr. Vasquez asked me anything concerning my case. Only thing that he's
done.
How
long has he been on the case with you?
Over 14 months, sir.
What about that?
And he's only came to see me 6 times within 14 months. He's never, not one, asked me about my case. He never even asked me if I done it. The only thing that he has done is keep on coming with the time that the DA has offered me, sir. That's the only thing this man has done.
I saw this in the letter. You feel as though he's more concerned about trying to work a deal.
Yes, sir.
Without preparing for trial.
That's why I'm frustrated, sir. I'm not trying to be funny or nothing like that. This is, like you said, this is my life. This is my life. And if he's not going to work and try to help me try to get back my foot in the world, what am I supposed to do?
What about that?
Judge, I've been on this case since it's been in your court. It was transferred from the 252nd. Mr. Senegal has seen all the discovery. He's seen all the video. We've announced ready for trial at least the last 2 times we've been here.
Okay, so you're prepared?
We're ready now, but I filed this because of Friday. He wanted me off his case.
What is it that he hadn't done to prepare for the trial?
I just want him to just look more into it. That's all. I mean, I'm not, and I'm not.
Well, I articulate. I don't understand. Look, what do you mean?
I gave him videos. 3 different videos, and those videos were sent to him numerous times.
Videos of what?
Of the alleged victim making accusations of having these charges brought up against me. No matter how they look, I would like those videos admitted into evidence on my behalf.
Well, the court is the gatekeeper.
I don't know, sir.
Then they have to be relevant and reliable.
They are.
You know, well, it's for me to decide, but I can understand how that's something you would like him to look into. What about that?
I have received no videos from anyone.
You told me you have, sir.
I've never received any videos from you, and I don't recall meeting you in 2013.
Who has the video? Hold on. Well, who has those videos?
Oh, my brother.
Get them to him. Can you get them to him?
Yes, sir. And not just that. I would like my old parole officer. I was paroled to this address.
Okay. What's the parole officer going to do? No. What does he help you with?
That I notified him that he's known of the situation before even it took place.
What situation? What you're charged with?
Yes, sir.
How would he know about it?
Because I spoke to him in front of the alleged victim concerning the what was going on. And like I say, even in those videos, months before this even took place, she made the statements of having me locked up if whatever I would do. And in those videos, it would show my innocence.
Have you looked into that? You're just finding about this?
This is the first I've heard of videos. And he may have mentioned videos in the past. I have received none. And this is the first I've heard about. And I knew that's where he lived.
It's 2 people that will vouch that he have seen those videos. My brother and my ex-girlfriend, a female, a young lady I talked to after that. He told them that he didn't want to use those videos. he actually told them, all you have to do is get in touch with Hope Boxy. I have her number, and my brother, Peter Senegal. Those two individuals that he talked to and told them he didn't want to use the video.
Get those. Somehow y'all work together.
Yes, sir.
Get them over to him. I want a hearing in 2 weeks to see what has been done and what everybody is doing to get ready. And getting that information to your lawyer that you want.
Yes, sir.
Okay. Mr. Vasquez, do you understand these two different things he's asking for? Let's get those. This is old. This needs to get moved.
I agree, sir.
It's too old to be unprepared at this time for trial, but let's get it cranked.
And I was registered as a sex offender at this address. My registration and everything, my license, the address on my license is everything is at this address. Everything is at this address.
You understand what he's asking you to do?
Yes,
There's
sure.
two things. What else?
Then police reports. We had numerous police reports. While nothing was filed about a domestic violence or a protective order or anything at those times, I never was incarcerated or nothing due to those 15 or more calls. I asked him to look those up. Those would show, okay, if he did anything, why was nothing done at those times?
Well, police report, it's just a police report. It's up to the DA's office to move forward on it for a crime. A police report is just an investigation, and it's that officer's version of what he knows.
Even in what it is, article 42.07, all elements of the case, those will show the elements of the case. Not just in just.
How do they show the elements of the cases?
They show sequence of what was going on, prior, everything that me and her had going on, sir. I'm saying, I'm just trying to. I did what I did in the past. I'm living to a better life. I'm trying to do better with myself. Even before I came in here, even with my parole officer, he would speak on that. Even past parole officers doing the 14 months that I was out, sir. That's what I'm trying to say.
Okay.
At the end of the day, I have to fight for myself if he's not going to fight for me. And I'm willing to fight for myself if I have to.
Well, he's practiced in this law, in this courtroom. He's been a lawyer for a while. And you're interrupting me once again.
I'm sorry.
See, who doesn't follow the rules?
I'm sorry. I'm just right now.
Who doesn't follow the rules? You do. You don't. But he's tried cases, and he's been successful in most of the cases he's tried in this courtroom. And I find him to be doing an adequate job. And I'm pretty good about knowing lawyers, whether they're competent or not.
Yes, sir. And
because I've done this for a long time, and I've been pretty successful for a long time as a trial lawyer. And trying 600 jury trials. And it just is a preparation issue that needs to be accomplished. But he knows how to conduct himself, and he's effective in court. You may not agree with the way it's done, but that's Monday morning quarterback. Every time the team loses a game, people gripe, even though they had a plan that worked in the last game. It just, people, this court is aware who are competent to try cases. And if they're in this court, they're competent, or they're not going to stay in this court. That's the way it is. And he does a fine job. So it's just a matter of getting this stuff that you want to him to review and to determine where it's going to play in the trial. Let's get this reviewed in 2 weeks.
And the same, I put a petition, sir. I got a petition that I would like to have admitted.
What is it?
A petition stating everything that's going on between Mr. Vasquez and myself, and the ethics of him, and the thing that I'm asking for. Even the same thing with my bond. My bond, here it is, the last time we was in here, November 13th of 2023. he made a statement as he's adamant about a bond. First of all, I am adamant about a bond. This is my freedom at the end of the day. And you just made a statement yourself talking about he's a good lawyer. He's a good lawyer from the state, sir. If you give me my bond back to the original amount, reinstate my bond. I never violated my bond or nothing. I was out 3 weeks prior to my indictment. Parole locked me back up. I was on parole at the time, so I'm asking for at least give me my bond back or reinstate the bond. I never violated my bond, not one bit. Never violated my bond.
Okay.
I have paperwork showing.
So what was the bond originally?
20,000.
Then what happened?
I got locked up on parole. Parole locked me up due to the indictment.
Okay.
And I never violated that bond, sir. I never. So that's money going down the drain. I even had a pay lawyer at the time.
But it was because
I was on parole.
Oh, okay. You don't see a problem with that affecting your bond?
Affecting my bond, like
yeah, it has something to do with the calculation of bond.
Yeah, but I never violated that bond.
I'm sorry, sir. If you're on bond and then you are indicted, that's probable cause to believe you committed the crime.
That's another thing. I mean, here it is. I'm guilty in your eyes.
No, it's not. It's the law. The law doesn't say the law, when it's looking at crimes on bond purposes, you don't have to be shown beyond a reasonable doubt. That's what the trial is. But your bond must be followed by a preponderance of the evidence or greater.
Okay, but
more likely than not.
Raquel West says she raised my bond up only so that I have back time. Okay, I mean, I've been in here 28 months. All I'm asking is to give back my same bond or reinstate my bond. That's all I'm asking.
Well, the bond was changed for some reason. It just wasn't whim. It was because you were on parole.
She said, and so that I have back time, sir. You can, October 26th is when she raised up my bond, and you can even look and confirm that.
All right, okay. We're not going to do that right now. If you want to have a hearing on this bond matter, I am always open for hearings on bond matters. Joe?
Yes, sir.
If that needs to be done, let me know. We can get that done pretty quickly.
Can we have it when we meet again, Your Honor, in 2 weeks?
Yeah. Yeah. If that's what you want to do. I'll hear it. Then we'll work through it. What else? What else? Just get this thing ready for trial. Is what I'm saying. Get it ready for trial.
We're ready, Your Honor.
He says you're not.
Yeah, if he said we ready, we ready. I'm ready.
No, you just said he's got to look at some stuff before you can come to trial.
He said that we're ready. I'm ready today.
Are you?
I'm ready, Your Honor. This is the first I've heard of.
Do you want to go to this? What are you asking for? Do you want to try this case today?
Yeah, I'm willing to try it today, sir.
All this that we've been talking about, you just forget about it and let's go. Let's move on.
I'm ready to get it over with.
Who is the district attorney on?
I am good.
Where are you on this?
I was ready, but now since I hear that he's requesting videos that the lawyer doesn't have, I don't want to try it twice for ineffective assistance if he doesn't have those videos. I've got a video of him in the house the night we have all this, and also got a letter from him admitting that he smashed in her windows in her car. So I don't know why he's upset, but I understand that he wants a trial. We can do a trial. I should agree with Mr. Laird, Your Honor, but you don't want to try it twice. If Mr. Senegal, if someone has videos, I should look at them to see what they're worth. Well, we can try it really quick. She's available. She's always local.
I'm gonna reset it in 2 weeks for a trial docket on 2 weeks.
Yes, sir.
Y'all try to get this done and get what he's concerned about reviewed so that you can either present it or decide not to present it depending upon the way it comes out. But let me reset it for 2 weeks for that.
And if you don't mind, have my old parole officer, because the same time of those videos I was told that address.
Yeah, he's the one. I don't go get them. He's got to get them. All right, reset in 2 weeks, please. Thank you. All right, that is all.
Thank you.
And we are in recess.
Right, same, right.
Thank you, Dennis.
Okay.
Okay. I was kidding. Thanos wasn't right. Mostly. Ladies and gentlemen, it's been fun. It's been an interesting 2 hours of shows. I really appreciate everybody coming around. I'm your Lone Wolf Usul. I'm your host for these here videos in this live stream every weekend at 11 o'clock Central Time, 12 p.m. Eastern Standard Time. We're looking for something to do during the week. Come by about 8 o'clock in the evening Central Time. I guess that's 9 o'clock Eastern Time. And I do a premiere of Fleischer's Daily Docket every night. We call it the Fleischer Forum, where we just kind of sit around and talk about what happened in Judge Fleischer's court, basically. Everybody's welcome to come by and hang out and do that. I think most people already come here and watch this on the weekends, hang out there anyway. Looking forward to seeing everybody there. I really appreciate everybody commenting. I am going to break these videos apart and use them as standalone videos, so those comments of yours do contribute to the videos of the channel to come. I really appreciate that. Ladies and gentlemen, it's been great seeing you. Hope y'all have a great Saturday. See you same Wolf time, same Wolf channel next time. Peace out.